of Detroit versus Nathan Lucas. Case number Nathan Daniel Lucas. Case numbers SP 106-84961, SP 1111617, counts 1, 2, and 3, SP 1111637, SP 1129810, counts 1 and counts 2. SP 1389565, counts 1, 2, and 3. SP 9644961, 22737166, counts 1 and counts 2, and 227371. Appearance for the record, please.
Good morning, Your Honor. Tana Jenkins on behalf of Mr. Lucas. Mr. Lucas, please place your full name on the record.
Nathan Daniel Lucas, a living man.
A living man?
Yes, sir.
I would think that would be obvious, right?
No, sir. Not in
No.
the etymology of the courts and the syntax grammar. No, sir.
You've gone above my head on that. I can't. That's above my pay grade. All right. So are you interested in a lawyer representing you, sir?
No, sir.
Okay. Are you interested in even getting a driver's license?
No, sir.
Are you interested in an offer at all?
No, sir.
Set the matter for trial.
Well, I intend to plead in the form of a demurrer, such that I do not acquiesce to quasi-juris.
Welcome back to the channel. Today's video is packed with some of the wildest sovereign citizen courtroom antics you'll ever see. We've got multiple cases, different judges, and defendants who seem to believe that if they just say the right magic words, the entire legal system will crumble before them. We'll watch one man insist he's a living man, as though that somehow exempts him from the law. Another who thinks writing return to sender on court mail makes charges vanish. And even a wheelchair-bound defendant charged with fleeing. The police? Each of these hearings highlights not only the absurdity of sovereign citizen logic, but also the sheer patience and occasional sharp wit the judges force to deal with it. Stick around, because what starts as bizarre quickly escalates into unbelievable. And trust me, you won't want to miss the ending, where the judges lay down some of the most decisive smackdowns we've seen.
Brought up in my pleadings and filed with a court.
I didn't see any pleadings filed with the court. Do we have anything?
I said that is an issue to be brought up. My pleadings to be briefed and filed with a court.
Well, you should have done that. Today is the date and time set for arraignment on the bench warrant. Kind of here. I'll enter a not guilty plea on your behalf, sir. I'll give you a $0 bond, and I'll set a trial date for November the 14th, 2024. Or if you want a pre-trial date to file some pleadings, I can set that for October 21st, 2024. Which one would you like?
You could repeat that, sir?
Pre-trial date, if you want to file some motions, pre-trial date will be October the 21st, 2024. Or
that will be fine.
Just set it that you want that date?
October 24th, 2024?
October 21st.
21st.
2024 at 8:30 a.m. All right?
Yes, sir. And just for the record, I did not enter in no plea. I don't plead.
All right. Well, I'm entering in for you. All right. Have a good day, sir. I'll see you back October 21st.
Classic sovereign citizen opening move, declaring yourself a living man. Now, to you and me, that sounds obvious, but in the sovereign playbook, it's meant to draw some imaginary line between your physical body and your so-called legal fiction. The problem? Courts don't operate on fantasy. They operate on statutes and precedent. Declaring you're alive doesn't make your charges disappear. If anything, it makes you look unprepared. Like someone who's memorized internet scripts but forgot the one thing that really...
All right, and all right, this is file 23-748FH. And who do we have from the people on this file?
That would be me.
Okay.
Melissa Goodrich, Wayne County Prosecutor.
All right, and we're here for a docket call and also then a contempt hearing for failing to appear. But I do note that there was an absconding case filed in that matter. So Mr. Kukuski, do you know how Mr. McLeod wishes to proceed today?
Well, Your Honor, we're not resolving this matter at this time. We'd ask that the hearing be continued at this time as well, given the new charge in that matter. Sorry.
I do see that the new charge is set for an arraignment on September 10th it was at 10 a.m. You want us to continue this to the same date and time?
Yeah, Your Honor, that'd be fine.
Okay, so let's continue this to a docket call to September 10th at 10 a.m. And we'll have the contempt hearing, same date and time. And that'll be the same time as the arraignment on the absconding charge as well. All right, anything further from the defense?
Briefly, Your Honor, I did want to request from the court a consideration on reinstating Mr. McLeod's bond. He is self-employed and has several jobs and opportunities lined up. This is the time of the year that he gets his work in as a contractor, kind of puts things away for the winter months. He's a sole breadwinner for his family and support for his wife and children. He's obviously no longer listening to outside forces and taking bad.
Is another sovereign citizen classic refusing to enter a plea. D. Logic goes, if I don't enter a plea, the court can't touch me. But here's the kicker. Judges have the authority to enter a not guilty plea on your behalf, and they do it every single time. The law doesn't pause just because you choose not to play along. In fact, all this maneuver does is waste the court's time and signal that you're not taking the process seriously. Judges don't see strength in these refusals. They see delay tactics.
And his sitting and bond being revoked, to my understanding, that's not going to happen again, Your Honor. He's got significant ties to the community. He was still in the community here. And so we'd ask the court to, and even on these charges, he's not looking at any sort of lengthy sentence.
I'm not sure that's true. He's got an absconding felony charge now that's discretionary consecutive. I mean, I haven't scored it, but
Sure.
he's really made a mountain out of the proverbial molehill here.
I would agree with Your Honor. I mean, he had to lead to a disorderly person. Certainly, that's gone to the wayside at this time. But we're just asking for the court to look at all those factors and weigh that into considering a release on bond again, Your Honor, and not to, I guess, hold. He's listening to bad advice, which he's not doing anymore against him, and come down from a place of anger, but to allow him the opportunity again. Thank you.
Thank you, Ms. Gooders. People's position.
Your Honor, my concern would be the pending absconding and his demonstration on bond of failing to appear. He has had the benefit of previous counsel throughout this case. I'm glad that he has retained counsel and appears to be communicating with that attorney. However, I still have concerns with his ability to appear for future court hearings.
All right. Well, I mean, last time when I was here, I noted that we had gotten mail back from Mr. McLeod. A second one came back that I guess had been kind of lingering. And again, just for the record, when he was purporting to represent, when he was representing himself, then he refused mailing from the court. I have a second mailing back from the court. And this is not somebody else's. I mean, I don't know where he gets the advice, but this was an adult man choosing, while he's representing himself, to write on it in red ink, return to sender, 18 U.S. Code 241-242, your offer to contract is not accepted, as if a defendant facing a pending felony charge has some ability to reject a contract.
Notice how the defense tries to frame this as just bad advice. It's an interesting tactic, almost like saying, my client isn't irresponsible, he's just misled. But here's the problem. At some point, adults are responsible for the choices they make. You can only claim bad advice for so long before it becomes clear you were an active participant in the bad decision. Refusing to appear in court, dodging mail, or ignoring bond conditions aren't accidents, they're deliberate acts.
Even the authority of the court and an outright refusal to appear, resulting in a forfeiture of the bond. And I mean, when people are facing a felony case, even though this wasn't the most serious felony case that we see, it is nonetheless serious. It's in the circuit court, court of general jurisdiction. People don't just get to opt out of that and say, I don't think the courts have any authority over me. Well, guess what? They do. And so I just have no confidence that Mr. McLeod respects the authority of any governing authority and that he would appear. He's refused to appear and now has an absconding charge.
When someone starts scribbling US codes on returned mail, that's not oops, I misunderstood. That's a willful rejection of the system. Sovereign citizens love to cloak this behavior in legal jargon, but when stripped down, it's basically, I don't like the rules, so I'm pretending they don't apply. The danger is obvious. If everyone did that, society would collapse. Imagine drivers saying stop signs don't apply to them, or defendants saying laws don't apply unless they consent. The courts have to shut this down hard because the alternative.
Mr. Whitlock, you have appears to be duplicate charges, so some of these charges are going to be dismissed, and you have two separate incidents. Because you're on active probation for the felony charges, I cannot provide you bond. So for the aggravated assault on police officer, fleeing a police officer, and for the obstruction felony charge, there will be no bond. For the theft by taking, that'll be a $1,000 charge as a misdemeanor. For the second incident, there is a no license charge, which is being dismissed because there is no facts to support it within the warrant. The tinted window will be $500. Use or possession of drug-related objects, $1,500. Identity fraud, no bond. Crossing guard lines, 2 counts, no bond. The wanted person charge is going to be dismissed because that's something separate totally from this incident. And giving false name or address or date of birth will be dismissed because there are no facts to support it in the warrant. So again, you have 2 counts of aggravated assault. One of those is going to be dismissed because there appear to be duplicate incidents. 2 counts of fleeing an officer. One of those is going to be dismissed. But at this time, there's no bond, which I can confirm which one's going to be dismissed. You'll have a minute to ask your question, Mr. Whitlock. I'm not done. The theft by taking misdemeanor, 2 counts, $1,000, and the obstruction of an officer is no bond. Your preliminary hearing is currently set for September the 9th at 8:30 a.m. In regards to court-appointed counsel, Mr. Whitlock, are you working? Did you want to be considered for a court-appointed counsel?
Oh, no, I don't want court-appointed counsel, but I do not receive to the, I do not.
Hold on. So you're going to hire your own attorney?
Yes, ma'am, I don't consult to the proceedings, and I would like to say things like, I already know.
This defendant stacks up a laundry list of charges: aggravated assault, fleeing, obstruction, even identity fraud. It's serious business, yet he still clings to the idea that by rejecting the court's authority, can sidestep accountability. What's striking here is how the judge balances authority with clarity, laying out each charge while dismissing duplicates. It's an important reminder. Even when defendants play games, the system continues methodically, ensuring that charges are fair, accurate, and supported by evidence. The law doesn't bend just because a defendant refuses.
But that don't say I'd rather be charged for that than when they're putting on me. They found that on a water fountain. I don't even know what a water fountain is. I was with the officer the whole time. Even the officers in there said, man, this is going to get thrown out because the officer was just being an a-hole and putting everything on me. I had none of that. I was with the officer the whole time. You could tell them.
Mr. Whitlock, this is not a hearing. I don't have the officer here. So when we have the hearing, all this can be brought forward for your preliminary hearing or for, your attorney who you hire who can help you negotiate this. Again, I'm advised this is not a hearing. This is just to tell you what you're charged with. So any other questions?
if I say I do not consent with these proceedings though, and, you know, I do not accept, you know, the terms, like,
Okay,
yeah. I
well,
do.
you can discuss that with your attorney. If you have no other questions or comments, you're free to go.
Now, this one more question, man. So
Okay.
that with what you was just charging me with, that had been in College Park. So is that a part of y'all?
College Park is in Clayton and in Fulton, sir.
Yes, ma'am. So I'm wondering, like, I thought I had to deal with Fulton County on that instead of Clay.
You have, looks like you have some Fulton charges as well, so.
Yeah, but the Fulton County charges is someone else. That's the way they actually locked me up and then let me out the hospital once he found out it wasn't me. So why they're still on me? Like,
This charge, let me just tell you, the charge that you're for the aggravated assault that was in College Park,
yes,
it is on or around July 28th it happened. So that is not the Fulton County one that appears to have happened around July 17th. So
so
there's,
that's Clayton County?
yeah, if the warrant was sworn out for Clayton County, yeah.
Okay, ma'am. That's all I was asking. Because I know that's gonna get handled. That's some BS. But because I ain't did that. My father is a police officer, a detective, so I'm not.
Really drives home the human cost of sovereign citizen nonsense. Courts aren't just about abstract arguments, they're about real lives, families, and communities. When a defendant rejects the law, it's not just their freedom at risk, their family's livelihood, stability, and future. The irony is that many sovereign citizens claim they're standing up for personal freedom. But in practice, they're often stripping it away from themselves and those who depend on them. The ripple effect of these choices
Locked up in front of the legends on Old National. I know this not, I just want you to understand. I got locked up in front of the legends on Old National. I have 2% in the legends. The man even told him, hey, yes, he owner, he's an owner. And they still, hey, let me search you and all that. Now, once they searched and seen, I was clear, I'm good. I know the officer, I buy them food. And the dude that was in, I also rent cars out. I have a Maserati truck I was renting out at the time.
Mr. Whitlock, I'm going to stop you there. Because you're doing too much. You're talking about Fulton County. I was trying to let you go forward and explain.
I need some professional help. Like.
Okay, well, you said you're hiring your own attorney, so they'll be able to help you with those charges, sir. Good luck.
I'm gonna have an attorney for the charge, but since you're a judge, you can tell me, like, why did they let me go? They let me go.
I can't tell you what happened in that case. I don't have those facts before me. I only have the ones I'm dealing with right now. So you're free to go. Thank you.
So what's my bond?
You have no bond because you're on probation.
I heard you give me a couple of numbers also.
There was for the misdemeanors, there's like $1,000 and $1,500 for the remaining felony charges. Those statutes don't allow a judge to give you bond if you're on active probation for felony charges.
Yes, ma'am. But even in Fulton County, they don't allow.
It's the laws of Georgia, yes, sir.
Okay. I thank you, ma'am.
You're welcome. Have a good day, sir.
Mr. Williams, you are
You say, talk to my lawyer, right?
Yep.
That even if I say I demand a bond.
have it. 3 different courtrooms, 3 different judges, and 3 sovereign citizens, all clinging to the same broken script. Whether it's I'm a living man, I don't consent, or return to sender. The outcome is always the same. The court proceeds, the charges remain, and the defendant is left facing reality. What we've seen today is a powerful reminder that courts run on law, not wishful thinking. And if you found this case as shocking as we did, hit that like button, share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, the next one is just as wild. You won't want to miss it.
That's not my name.
Of Breland.
That's not my name. I'm here on special representation. I'm
same as last defendant, Your Honor.
My honor, I'm asking.
Okay.
What is your status and what is your name? I'd like to know your name. I'd like to know your status. Of everyone in the courtroom, I would like to know what is your nationality and what is your...
So, Deputy.
Yes, ma'am.
I would like to know your
So
nationality. I
he
would like-
has charges in Jots and he has a paper charge. Let me see if they're the same warrant, and they're different warrant numbers. Okay, so I guess I do both sets. Let me see when these are.
know your nationality. I would like to know if you're a U.S. citizen of the United States. And so what is your status? You're a U.S. citizen of the United States?
All right, hold on one moment, sir. Let me review the warrant.
I'm asking you for your status and the status of everyone in the courtroom. I would like to know your name. I would like to know the nationality. I would like to know, are you a U.S. citizen? Once again,
Is he deputy?
status
Say it
of
again, Your
everyone in the
Is
courtroom.
he injured? Is that why why is he in a wheelchair?
Yes, ma'am.
I would like to know the status of everybody in the courtroom. I would like to know your name. I would like to know your nationality. I would like to know are you a U.S. citizen?
Deputy, do you believe that this gentleman is mental health or